This is not an overview of the latest programs which are being rolled out by the various levels of government almost on a daily basis. For a general overview about these specific programs, please visit the links provided for at the end of this slide deck. The information contained in this presentation has been gathered from a variety of sources, including the CCIM Institute, the American Institute of Real Estate Management, or IREM, and also draws from our firm's 30+ years of property management experience. I would also like to thank Connect Ottawa, in the guise of Bertie Fransgrove, for putting together the slide deck and for both the invitation and for hosting this event. Commercial landlords, many of whom were just learning to adjust their business models in the new shop-at-home reality, have again been faced with another crisis which threatens not just themselves, but the very people they depend on to sustain continued growth in investor expectations and confidence, their tenants. While general consensus amongst landlord and tenants is that landlords are expected to be empathetic, it is unrealistic to expect landlords have an obligation or even the ability to foot the bill for something that they are not responsible for. Nor would it be realistic for landlords' tenants to continue on as if business were usual and be expected to meet their monthly obligations to their landlords. In Ontario, commercial tenancies are governed by the Commercial Tenancies Act. The Act dictates that a commercial landlord may repossess the premises in case of default by the tenant within 15 days from the date of said default. Unless the tenant were to give up the premises willingly, the standard prudent practice is for the landlord to apply to the court for a writ of possession. I say prudent in this fashion because it is not an absolute requirement that a writ be applied for. This writ is subsequently served upon the tenant by the Sheriff's Department. However, the Ministry of the Attorney General of Ontario, in a March 16th statement, stated that in relation to eviction orders issued by the Landlord and Tenants Board, whose main purview are residential tenancies, that the Sheriff's Department was to postpone all scheduled eviction enforcements until further notice. This has had the effect of prohibiting the Sheriff's Department from carrying out any such writs, commercial as well as residential. It is important to note that the Ontario Superior Court of Justice is closed for all but the most extraordinary of issues. It would be difficult to argue that application for a writ of possession would qualify considering the circumstances we find ourselves in. Even if it were possible, is the eviction of a tenant the absolute best solution given the current situation? All other factors taken into consideration, and considering the substantial litigation and lease-up costs should a new tenant have to be found, I would probably argue not. So where does this leave us? Some landlords have already announced broad measures to assist their tenants. RioCan recently announced that it would grant an automatic 60-day interest-free rent deferral to independent commercial tenants who ask for it. Stateside, the Texas company Camden Property Trust, who specializes in residential apartment units, has established a $5 million US relief fund for renters who have been impacted by the COVID-19 pandemic. Renters can apply for grants of up to $2,000, which can be used for any purpose, not just towards the payment of rent. These are just two very relatively small examples of some of the steps landlords have taken. I was on a call earlier this morning with a landlord in Halifax who took it upon themselves to deliver care packages to their tenants. Now, mind you, their tenants are primarily made up of bachelor type style studio apartments, but to each one, they put together cleansing wipes, toilet paper, and a number of other things they thought might be useful. So tenants right across the board are already receiving in some small way, some relief from a large number of very, very responsible landlords. There are many examples of companies and independent landlords being good corporate citizens. And while the lease may not obligate the landlord to enter into negotiations under the current set of circumstances, it is my opinion again, as well as the opinion of the vast majority of property owners and their managers, that it is in the best interest of the landlord to engage in negotiations in an effort to find and provide short-term relief for their tenants. It has never been more important, and I'll emphasize this point several times during this presentation, for clear lines of communication to exist between landlords and their tenants. We are in uncharted territory when it comes to the pressures that both parties face, and there is no clear solution or path. The onus is on both landlords and tenants to work together to attempt to find something that works. So following are a few observations and possible solutions for both the commercial landlord and the tenant to consider. Landlords may choose to reduce or eliminate basic rent for a fixed period of time. Reduce basic rent for a fixed period of time and defer repayment by increasing basic rent once the crisis has passed. Commercial landlords may choose to reduce or eliminate both basic and additional rent for a fixed period of time. And again, they may choose to reduce both basic rent and additional rent for a fixed period of time and defer repayment by increasing the same basic and additional rent once the crisis has passed. Landlords may decide or offer to convert the outstanding basic and or additional rent to a loan and amortize the balance of the loan over the remaining term of the lease. That's one option several of the landlords that we represent have chosen to offer their tenants, and it's been met with very, very positive results. The landlord may also allow the tenant to apply their last month's rent deposit to the current period. A landlord may choose to allow the tenant to sublet all or a portion of the premises. Now, this solution is more of a consequence to the situation we see ourselves in rather than an immediate solution, but it is an option. The landlord should make the tenant aware that failure to pay rent without an agreement is a clear breach of the terms of the original lease, and that's important. Also, the landlord should make the tenant aware of what provincial and federal programs may be available to them to help them meet their obligations. Once again, above all else, landlords should stay in constant communication with their tenants, acknowledging again the difficulties both parties are facing, while seeking out a fair and equitable solution. I have a few other general observations that are more landlord specific. Landlords should approach their lenders, and in cases of severely reduced cash flow, they should request a postponement of their monthly mortgage payments. The big six banks, the RBC, TD, BMO, Scotiabank, CIBC, and the National Bank have all announced that they have introduced 6-month deferral programs for those clients who have requested such a system. If your financial institution offers such a program, take advantage of it. While there may not be an immediate need, we do not know what the ultimate outcome or timeline of the current situation will be. Does your property insurance policy or lease document contain a force majeure or act of God provision? Just because a force majeure clause may exist in your insurance policy in the form of a restrictive covenant or in your own standard form commercial lease, it does not mean that it is a blanket provision. A great deal will be decided by the wording contained in the clause and ultimately the court's interpretation of same. We'll speak a little more about that later. Landlords should also review the terms of their insurance policies to ensure that the policy does not fall into default because the property may be partially or totally vacant. If a landlord finds themselves in just such a situation, it is imperative that the landlord and/or the respective property manager inform their insurance company or broker. Further, from solely a property management standpoint, landlords should ensure that the property is secure, including the roof access, and is being regularly inspected. They should ensure that HVAC systems are not turned completely off. There must be adequate air circulation in order to prevent the development of molds, which can lead to other respiratory illnesses and diseases, including but not limited to Legionnaire's disease. The property at all times should be properly heated. Water should be regularly added to sinks and drains to ensure that sewer gases do not enter the premises. The landlord should also place adequate notice on all exterior doors indicating who to contact in case access is required or in case of emergency. It is also a good idea to ensure that unused equipment is powered down, both belonging to the landlord and to the tenant. From a tenant standpoint, it's important that you as a tenant read your lease. It's amazing the number of tenants that just aren't familiar with the contents of their lease. They've paid it a cursory glance or relied on their lawyer or another individual to read to them or point out to them the areas of concern at the time of signing, but circumstances change. So it's important that a tenant read and familiarize themselves with their lease. If, as a tenant, you are uncomfortable with the terms contained within the lease document, consult the services of a lawyer or a qualified real estate professional to help you with the interpretation. Understand what constitutes default under the terms of your lease. Understand what remedies are available to both you and the landlord. Does your lease contain a force majeure or act of God provision? Again, I bring this up. Again, I'm often asked about this specific clause. Have you given your landlord a deposit? Will the landlord consider applying that deposit to your current month's rent? Review your insurance policy. Better yet, speak to your insurance agent. Does the policy include a loss of income provision? If so, what is the procedure for filing a claim? Tenants should have a clear, definable ask of their landlord. Ask yourself, what do I need to survive these next 3 or 4 months? It's not good enough to just approach the landlord and say, I need help. Be specific. Let the landlord need what the ask is. Otherwise, what he comes back to you with may not be what it is you need, and you'll be in a position where you'll have to go back for another ask. Familiarize yourself with available government programs. Avoid, by all measures, avoid take it or leave it attitudes. It serves absolutely no purpose and may well prove detrimental should you at some point require or request a further lease concession or extension. Here the old adage holds true. You attract more bees with honey than you do vinegar. Once again, stay in constant communication with your landlord. Again, acknowledging the difficulties both parties are facing while seeking out a fair and equitable solution. Here are a couple of examples of force majeure clauses, which I've pulled from a couple of commercial leases. Essentially, the clause is a provision in a contract that excuses a party from not performing its contractual obligations because it has become impossible to fulfill due to an unforeseen or uncontrollable circumstance or situation. Essentially, what it means is that the contract has been frustrated. In one, the one on the left-hand side of the screen, you'll see they're referring to it also as an act of God. And sometimes rather than force majeure, it'll actually say act of God. In the illustrated examples, one clause, for instance, provides for a remedy, while the other one is left open. And if you were to read the clauses, and again, I welcome all of you to read the clauses and get yourself familiar with them by downloading the actual presentation. You notice that there's, in one case, a remedy, in another case, there isn't a remedy. So, but in both, it's very important to note that it succinctly states, both clauses succinctly state, that such a situation does not mean the tenant can immediately stop payment of their lease obligation. Some final general overall observations. Any concession should be documented on an amendment to lease document. It should clearly state what the concession will be, whether it's an adjustment to the basic rent, additional rent, or both, when the concession starts and when it expires. It should be signed by all parties to the original lease, including any guarantors. It should also clearly state that all other terms and conditions as contained in the original lease agreement dated blank shall remain in full force and effect. In conclusion, we will get through this by being empathetic and by educating ourselves. Plausible solutions to most any landlord and tenant scenario can be found. Be kind, be safe, and thank you for this moment of your time.
Thank you so much, Frederick. That was awesome.
Wonderful. Thank you, Margaret Ann.
So I will open this up and to our viewers here to ask any questions, Fred, that you'd like answered.
Well, Fred, I have a question for you.
Sure, Bernie, shoot.
For the guarantor, so far we talked about the landlord and the tenant and the guarantor. So how much of a communication process or what type of relationship would come out of that? Like how that, it's like having three-way conversations instead of a two-way conversation. How complicated can that be?
Well, essentially when we're talking about guarantors, we're talking about people that were party to the original lease. For instance, someone who starts a new retail business may not have the facility or the credit history to afford them the ability to actually enter into a lease agreement with the landlord. The landlord may then ask the applicant whether they have a guarantor, someone who's willing to guarantee the lease for the tenant. What I'm referring to is the fact that anytime there's a change to an original document, a lease document in this case, it is important that all parties be notified of the change and all parties agree to it. Not to do so may erase the ability of the landlord to collect from a guarantor if the guarantor wasn't made aware that there was an adjustment or amendment to the original lease. It's not unlike having someone co-sign for a loan, any loan, a car payment, for instance. If the original tenant were to default, the landlord would be absolutely within their right to go after and seek remedy from the guarantor. Does that answer your question?
Yeah, it does. Thank you.
Super, great.
I have a question.
Hi.
It's Shane, Proactive Sports Injury Clinic.
Hi,
I just
Shane.
have a question about, obviously we're going through some tough times here and we're obviously forced to being closed and not having any income coming in. And we're talking to our landlord and stuff like that. And everything's about deferral. Now, obviously I think the payment period will change if this lasts longer than most people expect.
Mm-hmm.
But at the same time, we're taking hits. We're never going to be getting back the days that we've lost in clinic and income. But what is the landlord doing to say, you know what, I'm here with you, because they're all saying that we're here with you, but if you're deferring that payment, you're still going to get the money in total. Where's the fact that let's meet in the middle or something like that, getting a discount, or even putting extra months at the end of the lease or something along those lines. I just feel like it's one-sided. The landlords are still being able to, because they have these contracts, the leases, to get the full payment, but they're not really giving back to us at all on a fact of, yes, you want us to keep being tenants because you're not going to get anyone to rent it right now anyway.
Mhm.
So I'm just kind of thinking, is there another meaning that's fair going both?
Shane, thank you very, very much for the question. It addresses a point that I made, and I was trying to emphasize the point when I was suggesting or proposing remedies. There is a big difference between total forgiveness and deferral. And you're right, most landlords, at least initially, will take a deferral position. That way they don't, as you so aptly pointed out, it's not going to really change their bottom line year over year. In this particular case, again, I think it's important to emphasize that point with your landlord. Most landlords are being very reasonable. What I'm finding is that the original take back from all this is to do exactly what your landlord is doing. What your landlord is saying, look, we'll defer, defer, defer. I think it's important, depending on what the business is, that you emphasize the point to them. And if you're having difficulty communicating that, it may be an idea for you to find yourself an intermediary that can turn around and discuss this with him on a different level, or his representative on a different level. There is not any type of absolute or short-term solution to the problem or issue you're resolving. As I've illustrated, or I'd like to think I've illustrated, there are real broad spectrums here. We have landlords that can't do enough and are offering all sorts of cash incentives to their tenants, residential and commercial. And then we have others who, as quite frankly, a minimum, are deferring. There has to be a happy compromise. Again, there isn't any magic wand that I can wave except to communicate exactly the issue that you brought up. I'm sorry, Shane, I can't be more specific. I can't bring up anything that'll magically resolve or help the but this is really boiling down to communication. It's really, negotiating with landlords saying, look, we're not going to be able to do this. Because a lot of landlords, if a landlord is going to take a very, very hardball approach, a lot of landlords are going to be very surprised at the end of the day when their units end up being vacant. And that's the balancing act here. If you can't afford to pay rent and the landlord isn't being sympathetic, what alternative is a tenant going to have? A landlord does not want to see you leave, but at the same time, you really must make your point, a strong point with your landlord, saying, look, we can't afford this. We need more than just deferral. The other thing that you might want to consider that we didn't actually speak about was the possibility of extending your lease term. In some instances, that may be a benefit to the landlord, particularly if the property or the area that you're leasing was vacant for any length of time. It may be that you agree to turn around and say, look, for the next 2-3 months, we're having a difficult time. We don't have the funds to pay the rent. However, what we will agree to do is extend our lease term by the number of months that you give us as far as relief from the current situation. That also helps you too, because what it means is that your rent is fixed at your current rental rate, which usually at the end of the lease term, if it's done correctly or with market conditions in mind, will be somewhat less than what maybe the current per square foot lease allowances for the premises you own. So that's something you may want to consider and go back to them with, because there may be some value for both you and he. That's all I got, Shane. Sorry.
Hey, thank you very much for addressing the issues. I know it's a difficult question when we're the first time we kind of be involved with that. And I guess another thing they've always brought up with me is like we didn't pay a setup fee for when we upgraded into a bigger place to change some of the walls and stuff. So they're always saying that we did this for you. A lot of people, we put it up front. So You know, they're always kind of going back and forth. And the big thing I said to them is I say, you know what, I understand you guys have expenses that we might not see, and just like you might not see what's happening on our end as well. And I said, I just want to see facts. So in our company, we always say, if you want to see how much we make and whatever, here, I'll show you the bottom line. And I said, that's all I want to see too, so that we can see how you're struggling and how we're struggling, and so that we feel like, you know what, you're legitimately doing your best. And that's kind of where we stand.
Wonderful. Well, I think you're doing the right thing. Maybe reemphasize the point with them. There are options out there and there are solutions. I'm a firm believer that two people can look at the same situation and one can say the sky is a bright, beautiful blue, and the other one can see darkness on the horizon. But even if you're miles apart, you can come together and at least agree that maybe the sky looks turquoise.
I love that analogy, Fred. And I think that what keep resonating is conversations. Conversation is the key to success. That just be open and honest and possibly come to a resolution. That's what I just keep hearing through all this. So that's
it's difficult for some people to actually get to that point or even to ask. I mean, Margaret Ann, you and I were discussing this just before we opened up about asking. About some people have a real tough time doing that. And in some cases, that's where you may want to call on the services of an intermediary. But never be afraid to ask. If you don't ask, you don't know. If you don't ask, you'll never know what was possible. So never be afraid to ask.
good
So
advice.
one of the things I noticed, Fred, we have the Canada Emergency Response Benefit. Can you go through a bit more on the, like, we see the 2K for the 16 weeks for the self-employed or the employee, I should say, the CRA account. Are there other options that the government's offering to businesses that could be deployed towards their rent?
Well, I'm by no means an expert in this. I can suggest to you experts, because I had a somewhat lengthy conversation with one myself this morning on behalf of another client. So I don't even want to stick my toe in. However, I would suggest to you that most CAs are very familiar with what may or may not be available. There's an entire issue revolving around what your business actually is and how your business is impacted. And when I'm referring to business, I'm talking the business of being a commercial landlord. So there's a lot more involved here, and it's something that I'm not fully qualified to address. But I would suggest to you that the individual who should know, who's been able to answer the questions for me, is a CA, any type of chartered accountant, someone who has made themselves familiar with it, because no doubt they're being inundated with all sorts of requests for information. But my understanding is that it's not that difficult. What we're dealing with here is more definitions more than anything else. Sorry, I couldn't be more help with that one, Bertie.
Oh, no problem. No problem at all.
I'll just mention I actually got a document from McKay and Duff, April Wheeler, and I just put it in the chat box, and it's a very in-depth guideline about different benefits and stuff, so that might be of value to people. I think you can download it. It's the first time I put a document in the chat box, but we'll see how it goes. It might provide some assistance or some advice for people on the call, and it is from a chartered accountant.
Yeah, I've found most of the major accounting firms, the one that I use is Henry Warren. They all have issued statements or handouts or outlines to their clients dealing with a variety of these issues, but they are best really to answer those questions.
Yeah.
Thank you.
On behalf of that, I think what I've noticed is that the government when they see the loopholes, and we've had some business people in Ottawa that are stepping up to the plate and having meetings with the Minister of Business and stuff. What it was nice to see is that the doors aren't totally closed. Again, it's the ask. The people that are being very, asking, making suggestions, are paving the way for others, because there is a lot of loopholes. Nothing is cut and dry in business. So I think it's important to educate, keep sharing, and do that ask, because the government, to me, it's listening to people, like, you know. So Bernie, did you have another question?
I always have another question, Marianne.
Oh.
So Fred, if someone wants more advice, just can they reach out to you?
Oh, absolutely. By all means, you can reach me at this particular email address, visit our webpage. But thank you very much. Always available, always happy to assist any which way I can.
And Fred, I also understand you're going to be putting on an online course soon that's going to be covering real estate for those that are not
Nothing escapes you, does it? Yeah, we're probably going to be launching mid-May, but it's a course very specifically geared towards the neophyte investor. It's a type of course that isn't available right now, nor have we been able to find it, but it's going to go through some very basic must-knows. It's about a 3-hour course. There is a fee attached to it, but for someone who has any interest in investing in real estate, whether it's commercial, in any guise of commercial, retail, for instance, industrial, anything along those lines, and even residential, I think it'll prove an invaluable course for them. I really encourage you to visit the webpage. There'll be a notice up probably within days as far as registration is concerned. Again, thank you, Bernie. Thank you for bringing that up.
We actually have a question from Jason Dashnay. Go ahead, Jason.
Hey guys, and just more of a comment and trying to find solutions. One of the things, Shane, and for everybody else out there who's on a lease is, there's some criteria in around the 40K loan that you can get through your commercial bank, but that could be a good measure. Let's just say your lease is, $4,000 a month. You can access 40K. It's interest-free loan, and as long as you've paid 30K of that back by December 31st, 2022, the government will actually forgive, and you meet the criteria, of course, they'll forgive 10 grand of that, 25% of that. So that might just be a solution for those who are looking not only for areas to help mitigate rent for the next couple months or longer, but for any other, solutions for their businesses.
Yeah, thank you for bringing that up. That's absolutely true. Absolutely true. It'll hold more helpful, I think, for retail, the retail people or business people that are listening to this currently. But wonderful. Thank you for bringing that up.
Thank you. We've got another Shane. Would you like to come back on? You've got your hand up.
Yeah, just the one thing was with Jason, just they still have that $50,000 employee paid fee kind of thing for the year before for that $40,000 grant, because I'm waiting for them to drop that, and then I might be able to be eligible.
Yeah, there seems to be. I had spent quite a bit of time discussing that this morning, that specific point, and the only thing I can personally suggest is that you really keep up and aware of the changing criteria for accessing any of these funds, because it's changing again almost on a daily basis. One point that we discussed this morning was salary versus dividends. What counts as salary, and can dividends be counted as salary for those people that own or run or operate their businesses through corporations? The short answer to that is yes, which was very surprising, but it was made on a separate announcement that yes, if you draw a dividend from a company rather than salary, it does count as a form of income for qualification for any of these.
You can't see me right now, but the smile on my face has just gone from small to large.
Oh, good. Wonderful. Super. Then you should turn around and take advantage of that.
Perfect. Anybody else have any questions?
So I have a question, and it's, I don't want anyone to take it the wrong way, but you know, what are the investment opportunities out there? You know, I'm empathetic to, you know, people going through hard times, and I'm going through struggles, but there must be opportunities in real estate investment or some type of investment that's out there, right?
Wonderful question. And that's right.
You know, one of the things that I see is turning into certain commercial real estate into 3PL facilities, because 3PL is only going to grow.
Well, I happen to know a fair bit about both. Um, and I've been involved in a number of 3P projects. So I don't know whether that's necessarily readily available because again, you're dealing with public funds, and I believe a lot of municipalities may be really pulling back on all but the most absolute necessity of projects right now, because a lot of their funding, emergency funding, is being redirected. But that always is a wonderful, if you can get involved with a 3P venture, wonderful, great. I have, and in all three instances, they've been successful. As far as investment opportunities are concerned, yes, absolutely. There are going to be some incredible opportunities. Now, the big bulk of my business, what I do outside of the property management arm, is I deal with, as Bernie alluded to, distressed properties. And what a distressed property is, it's a property that we refer to as, which in my case, I'm dealing with primarily with lending institutions. I'm dealing with the federal government. I'm dealing with court-appointed receivers and trustees on a real estate-related front, meaning I anticipate that my concentration of business is going to expand exponentially. And along with that, and that essentially is securing and taking over and managing just these properties that have fallen into default. Everyone wants to be empathetic. The reality is that, you know, there's always some good with some bad. In this type of economy, as in any downturn, which everybody is anticipating is going to happen, primarily in the retail area, which encompasses strip plazas, malls, that type of thing. There may be circumstances or opportunities that a careful investor can take advantage of. And because there will be some landlords who maybe haven't made the necessary arrangements, don't have the horsepower to be able to power through this downturn, who will eventually fall into default. Now, most lenders will not have any problem extending terms. I alluded to it in the presentation, and that holds true. If you own property right now, retail or otherwise, and you're having difficulty, most lenders are going to be very empathetic, and they will extend to you terms. But what happens in an instance, for instance, where the landlord hasn't exactly been, he ends up losing tenants. Maybe he's one of those landlords that just isn't listening to the tenants, and the tenants end up leaving for no other reason but they're unable to keep the doors open. And because he wasn't accommodating during this process, maybe they've chosen to leave. Maybe they can't afford to carry on. So there will be a point where lenders are going to say, you know, okay, all right, we've given you opportunity or time to recover. And if you haven't, well, we're going to have to take what steps are available to us. And one of those steps for a lender is to turn around and take possession of the property. So stay in touch. I'm sure these opportunities will come up and make themselves available, but it's going to take a little bit of time. It's not going to happen tomorrow. I'm thinking closer to the end of the year, 5-6 months out. So if you stay in touch, I'd be happy to keep you apprised of what's going on. Thank you.
Okay, thank you.